Hey folks, again, my guest today is Travis Hollifield. He's an attorney right in Winter Park, and he focuses on women's workplace issues, and he knows what women want in the workplace, and he's here to lend us his expertise today. Let's go to Nathan. Nathan has another workplace issue. Nathan, you're on News Talk WDBO. Go ahead.
Yeah, I had a question for Travis in regards to FMLA. My wife she's actually in a residential treatment facility right now. She's going to be there for 2 months. I read that FMLA entitles you up to 12 weeks of basically guaranteed employment at your current wage. Her employer is only offering her 8 weeks before she basically has to be rehired, and she loses all her raises and everything that she's racked up over the course of the past 5 years and is basically, like I said, rehired. And I was wondering if there's anything legally wrong with that.
Well, the answer is kind of complicated, as these cases typically are. The question would first of all be if your wife is an eligible employee under the Family and Medical Leave Act and if her employer is an eligible employer. And the first question I would ask anybody is, how many employees are employed by your wife's employer? If there is 50 or more, and there were 50 or more within 75 miles of your wife's primary workstation, and if your wife worked for the company for a year, at least, and if your wife worked at least 1,250 hours in the 12 months immediately preceding the need for leave, then at least there's a potential of eligibility there. And if your wife and the employer are both FMLA eligible, then yes, she would be entitled to 12 weeks off to care for her own serious health condition or that of a close family member. It's unpaid leave, not paid leave, but the hallmark of an FMLA claim is job reinstatement rights at the conclusion of that leave.
All right, great question. We appreciate that, Nate.